Hello, everybody. This is Brian Gormley. I'm an attorney and real estate broker with Cornerstone Properties, and I wanted to take an opportunity to record this webinar for folks who are considering doing a short sale and/or are fairly well versed and interested in doing it, but just want to get some basic questions and disclosures answered, and kind of get a little bit more familiar with the process and at least our process for negotiating these and getting them approved and ultimately settled. I'm an attorney and broker with Cornerstone Properties, and if you do have questions after this webinar, please do submit them in the comment box, on this website, capitalshortsale.com. And we'll do our best to get back with you, hopefully within 1 or 2 business days. Okay, so let's go ahead and get started here. First, let's do a little quick top 10, and before we get into the real substance and meat of this, the top 10 challenges and pitfalls of short sale negotiation. If you're familiar with short sales, you might get a kick out of some of these, and some of them are just. Some of these, frankly, just big no-nos. You really got to be careful. When you're processing this, it's not like a normal real estate transaction. It's a lot more complicated, and there's a lot more moving parts that go on. So, number 10, wishful thinking. These things take some time, and that requires buyers to be patient, and it requires sellers to be patient. Frequently, escalations are needed. To move files along or to challenge terms that the lender wants to impose, and so on. And it's a multiple month sort of process. There almost always will be stumbling blocks along the way, and the better prepared and the more you expect that going in, the better time you'll have in dealing with what is admittedly a very stressful situation. Another big challenge that we've seen quite frequently, especially lately, is buyers' inability to close deals. Lending restrictions and underwriting guidelines have tightened severely in the last couple of years, and particularly within the last, say, 12 months. And it's tougher to get a loan these days. And so even if you do get your way through the process, a buyer may not be able to close. Number 8, assuming people will do their job. You wish that people would be competent, professional, would do the things that they say they're going to do, or at least they do the things that they get paid to do. But unfortunately, that's frequently not the case. When we'll go through sort of the process of a short sale here in a minute, but a negotiator is the person who is an employee of the lender, and they get paid by the lender to try to mitigate the loss to the ultimate investor, the entity that owns your loan. And if you accept their blanket statements of what is possible, what's not possible, fees that are going to get paid versus not, counters and purchase prices and all of that, if you just accept that willy-nilly, then you're likely going to have a problem. They lie frequently, they exaggerate. It's their job. It's their job to mitigate as much loss as they possibly can. So, they hide behind the quote-unquote investor, the mythical creature in the room that seems to pull all the strings. That investor is the entity that owns the loan and does determine the guidelines under which they will accept a short payoff. However, that's they're not this entity that is so amorphous and so kind of black box-ish that they can't be reached and terms can't be negotiated. Losing track of the foreclosure sale date. This has happened. Unfortunately, I'll admit it's happened to us on a deal or two. So important that you stay on top of when a foreclosure is scheduled to occur. Lenders don't always do this, we've had an approval letter, for example, issued 1 or 2 days before a foreclosure sale date. It was just absolutely ridiculous. Why the investor wouldn't, and they did postpone the sale, but why the servicer didn't postpone that. Number 5, following short sale lender guidelines. of when to follow up. This is, as I said, is a very long process, multiple months. The folks you deal with at first are generally the customer service people, and they will tell you follow up in 2 weeks or 4 weeks, or we have a time frame of 2 months. If you just let your deal sit for that long, you're going to be in trouble. It won't go anywhere. Non-first mortgage liens are always a challenge, whether it's a second lien on the property like a HELOC, or it's some sort of water lien or a homeowners association or condo lien. Perhaps there's a credit card judgment, something like that that has attached to the property. These things all have to get paid, and they definitely make your deals much more challenging to get done. We've seen everything, though. We've seen tax liens. We've seen $8,000 or $9,000 water liens. We've seen judgments. If it's been out there, we've seen it. Okay, number 3, very important, allowing the BPO agent to do what they want to do. We'll get into this again in the process section, but basically the lender will order a value of your property, and if you and that's done by either a real estate agent or an appraisal. And if you sort of let them do what they're going to do, they will always come in with a high value. And if they come in with a high value, that substantially jeopardizes your ability to get a short sale approved. There's no two ways about it. It's probably the most important thing in the short sale process. If not the most important, certainly one of the 2 or 3 most important things. Though the thing that I like to think of as equally important actually is number 2, and that's escalating files. It sort of goes along with some of these other points as well. You got to be able to talk to vice presidents, investors, asset managers in order to get deals through. And finally, thinking like a traditional real estate agent. Unfortunately, most of the market these days, doesn't really know what they're doing, and that's just the reality of it. And as a result, 10 to 15% of short sales finally are successful and go to settlement. And there's a reason why it's so low. If you think like a traditional real estate agent, where you're just going to sort of throw the property up on MLS, start high, work your way down, kind of guess at value, it's just not the way to go. And guess what? Your short sale is not going to go through. Okay, so quickly, background for me. I went to college and to law school, got a master's in public policy as well. I've been negotiating these short sales for 5 years, as of 2011, started in 2006. I used to work on the secondary market. Almost everyone's heard through the news these days how loans were purchased and bought. They ended up getting securitized on the secondary market by big companies like Freddie Mac and Fannie Mae, and other large investment banks like Goldman and Lehman and Merrill Lynch and so on, and repackaged. And so I used to work in that arena on the secondary market. I moved over to the primary market at one point, and did multifamily housing finance using tax-exempt bonds and low-income housing tax credits. And finally got into this space where we're helping homeowners get out of very stressful and difficult situations. And of all the jobs, I actually enjoy the one I currently have the best. Surprise, surprise. Okay, so process of a short sale. Actually, let's just stop for a second, just in case you don't know. A short sale is when you owe more in your house than it's worth. So if your mortgage balance, say, is $300,000, and the value of your house is $250,000, then you can't sell your house unless you come up with the difference, out of your own pocket, or you get the lender to agree to take less. And that latter option is a short sale. Most people are delinquent at that point because they can't continue to make their payments. They've got some sort of hardship, and so those 2 things. It's not necessary, and we could talk about that more later. But it's frequently the case that people are either in pre-foreclosure or are in imminent risk of default, meaning they're going to not make their payments, if not now, certainly in the foreseeable future. So those 2 things, having a hardship and having an upside-down property, are the 2 sort of essential components of being able to qualify to do a short sale. Typically, they do take 3 to 5 months to process from the start when we first receive the whole package to the time when the property goes to settlement. Some certainly can take longer if they have a lot of hair on them. Some can take shorter, but frequently it's not a lot shorter. It just depends on your lender, their processing, and what's been done on the file before we may have inherited it. and what all is entailed with the property. For example, if there's mortgage insurance, it's going to take longer. If there's a second or third lien or a tax lien, it's going to take longer to negotiate those things out. If there are certain servicers that just don't seem to want to do short sales and they take umpteen months just to get the file set up, then that's going to take longer. So the general process, we would get a full package right from you up front. We're going to provide, after you finish listening to this webinar in full, the package for you to download here on the site. And you can please do that and start filling it out. If you have any questions, let us know. But certainly if you want to review it, that's great. We would then take that package, add a thing or two onto it. I prepare a HUD-1 settlement statement, for example, and then submit it to the lender, and they will receive it along with thousands and thousands of other files. And then from there they'll order a value. What you heard me mention before, a BPO, a broker price opinion, or an appraisal. It depends on the investor and if there's an insurer, what their guidelines are. FHA, for example, requires an appraisal. Most of the securitization trusts that own these loans might just have a BPO ordered. And then the value is done, and of course we'll want to meet the BPO agent at the property and show them the comps that we believe are most relevant, and so on. And of course, part of this process is getting your property out into the public sphere, so marketing the property, getting a buyer to want to purchase it. At the banks, back to the bank after they get their BPO. They'll get a negotiator assigned who's the sort of point of contact for processing the short sale. After they've received all of the documentation, confirm that, the negotiator will compare the BPO value against the offer and determine if the deal makes sense for the bank. Ultimately, what they're doing is comparing their options. A is a short sale, and B is going to be a foreclosure. So if they get more money from a short sale, they're going to approve the short sale. If they get more money from a foreclosure based on the offer and their expected value, then they're going to do a foreclosure. It's pretty much as simple as that. There are certainly some specific terms that may get in the way here or there, but that's certainly the gist of it. Finally, when the investor has had an opportunity to sign off on the deal, which the negotiator would facilitate, an approval letter is issued that would outline the terms of the bank's willingness to release their lien and allow the property to be sold and the new buyer to get clean title. And then you would go to settlement, which is sort of a more just a traditional part of the real estate transaction process, where the buyer would do their own appraisal if they need to, if they're getting bank financing, run title work, typical underwriting process, for the buyer would happen, and then their loan would get approved, and you would go ahead and move to settlement. Okay, so a few things for homeowners when considering this process. In terms of expenses, you don't pay anything to us. It's zero. You never pay a dime to us. You have, pursuant to the latest FTC rules, you have the ability to decline the short sale really at any time, even after the approval letter is issued, and you don't owe us any fees. All the things that we get are payable out of sales proceeds. There are a couple of things we ask homeowners to try to keep up with. Utilities and homeowner association or condo association fees are two of them. These are things that homeowners are responsible to pay generally, and short sale banks typically do not pay. And so as a result, if they remain unpaid, or even worse, if there's a lien on the property as a result of a water bill, for example, they become very difficult and a real stumbling block to get short sales finally to settlement. Ongoing mortgage payments, certainly for the homeowner you have an obligation under your promissory note to continue to make payments. However, many people like the idea of kind of living rent free, and they sort of under the guise of, hey, look, we're every dime we pay the bank at this point is a dime we'll never see back. And certainly it's true that if you're delinquent, you stand a better chance of getting a short sale through. And so, to the extent that homeowners are suffering some hardship financially, and there is an incentive for them just to stop paying. That you don't need to be in default typically for a short sale to go through. There are a couple of exceptions. FHA, for example, if you have an FHA loan, you do have to be 31 days late as of the time of settlement. And it also, you have to show hardship, obviously, as we discussed before, to be eligible for a short sale. So important to be able to do that. Most people obviously can, otherwise they wouldn't be looking at doing a short sale in the first place. At the end of the day, in terms of making those mortgage payments, it's really a trade-off between keeping your credit and making payments, to the lender, and that's really the decision that you as a homeowner need to make. Other liens, definitely are things out there, tax liens, water liens, material liens, repairs and so on. Things to consider when doing a short sale. Okay, so let's move on with the listing particulars, things that we do. When we get a deal in addition, obviously, to processing the documents, the first thing we do is look at the property, look at the condition, look at the likely type of end buyer, who's going to buy this, and are they going to live in it? Are they going to rent it out? Are they going to fix it up? That's all going to go into what type of marketing strategy and what kind of value the property has. We'll certainly pull comps and see where the numbers are, and then also we'll want to look up the foreclosure sale date and determine how much time we have before a sale is likely to happen, and what we need to do with the lender to negotiate that away or postpone it. Listing price, again, we list properties very aggressively. So after we've pulled the comps, we're looking to get 1 to 3 full price offers within the first 3 or 4 weeks, for at least for properties that are in good condition and and are going to be lived in by a retail buyer. There's definitely different things that go on with investment property, and investors definitely like to get deals. There's lots of inventory out there, so it's it can be more difficult to sell those, but definitely cash buyers are out there in force these days. And certainly we do not go by the approach of starting high and working way down. We start low, and from there, if we're too low, we'll work our way up to the extent that the short sale lender is going to require that. Okay, there are 3 very important disclosures that everyone needs to know, and when you're thinking about doing a short sale, and most people ask about these, so let's just get them right out of the way. The first thing is deficiency judgments. In the area in which we work, Maryland, D.C., and Virginia, all 3 states are recourse states, meaning if you do a foreclosure, you go through a foreclosure, the bank has the right to pursue the difference between what they net from the sale of the foreclosure and what's owed under the promissory note. For a short sale as well, they have the right to pursue a deficiency judgment unless it's waived by the lender in the approval letter. Certain loans like FHA, and if you do a half a short sale, they waive the deficiency just programmatically. But that's not necessarily true, and so it's very important to review that approval letter if you want to make sure that you're not going to have a potential risk for a deficiency judgment. Certainly, it's the case if you do a short sale, you're less likely to have a deficiency attached, especially for a first lien. Second lien's different story, but first lien's for sure. It's very unlikely that they will pursue a deficiency, but you don't know that for sure unless you get that deficiency waived. So that's sort of the general deficiency disclosure. We're very aggressive about getting these waived. There are other types of deficiencies, though. One is a promissory note. The lender or the mortgage insurer may ask for a promissory note from the seller for part of the loss when you do a short sale. They'll look at your bank statements and your other assets and determine if you've got the wherewithal to continue to make some payments. Mortgage insurers are notorious for asking for either a promissory note or a cash contribution. That's the other example of a deficiency. A cash contribution would be the seller actually bringing money to the table and to add to the lender's overall net. So that's important to keep in mind. If you're current on your mortgage, that is you definitely have a higher risk if you're current of getting that kind of request back. 1099 deficiency waiver, I'll talk more about that in the next slide with the taxes, so let's skip that for now. Freddie is an example, another example like FHA, where they typically will waive the deficiency. That's their stated policy, at least as of now, could change in the future. The things that we do to get those deficiencies waived, if the lender is not willing to do it up front, obviously escalating the file, we can also offer up a little bit of extra cash if the lender drags their feet. Typically that's provided by the homeowner to get the deficiency waived. The argument is, look, you're just going to sell this loan to a collection agency, so why don't we give you what you would get, pennies on the dollar, for what effectively is the sale of the loan, or the collection rights, and then have you agree that you're not going to pursue the deficiency. You should be indifferent to that, and obviously on the homeowner side, it's they much prefer getting that assurance that there's no judgment looming in the next few years. Okay, tax applications. There are two types of forms that lender might send. They're 1099-C or 1099-A. The A comes from after a foreclosure. The C would come after a short sale, and that's when the lender is writing off the rest of the loan. And so that happens when it's a cancellation of indebtedness, and under Section 108 of the tax code, that's income to homeowners. Now, there are a couple of exceptions before people jump off the deep end, whereby the homeowner does not need to pay that, and frankly, most homeowners do not have any adverse tax consequences as a result of doing a short sale. The first exception is primary residence. If this is your primary residence, chances are that you're not going to owe any taxes. There's an exemption for your primary residence. If it's purchase money, meaning the loan you currently have out there is what you use to buy the house, then you're exempt from taxes. HELOCs are not exempt. However, if you use the money from the HELOC to improve your house, do rehab or remodeling, that would be exempt. It's got to be a qualified residential expenditure, but otherwise it's not exempt. And if it's a HELOC or if it's a refi, again, the refi, if it's a cash out refi, to the extent that you pulled money out and you didn't use it to remodel your house or improve your house, then that portion is going to be potentially taxable, and it would fall under the next exception, the insolvency exception. The insolvency exception would apply just like we were talking about for refis, cash out refis, that portion that you pulled out, or second liens where it's a HELOC, or if it's an investment property, you would fall right into the insolvency exception, and that goes something like this. You tally up all your assets, which would be cash, stocks, bonds, value of other real estate, etc. And then you tally up all of your liabilities. That would be credit card outstanding balances, mortgages, including the mortgage on the subject property, car loans, student loans, etc. And if the assets are equal to or less than the liabilities, then you don't owe any tax. You're quote-unquote tax insolvent. And you're only going to owe tax to the extent that assets are greater than liabilities. So if you've got $100,000 of debt being canceled, and you have $20,000 of assets in excess of your liabilities, then you would have $20,000 of taxable income if it's not your primary residence, and then you multiply that number by your marginal tax rate. So say 25% or whatever the marginal tax bracket you're in. Most people are tax law insolvent, and so they don't have any tax law implications. There is another nuanced point for investment properties. There, if you've got a return of basis, so you could have additional tax liability. So, if you've depreciated your property and your basis is even lower than the purchase price, then there's going to be two components there. Let's put some numbers to that. If you had a $100,000 loan on a house and you've depreciated, now your capital basis is 15, and you sell for 20. Well, you've got cancellation of indebtedness of 80, and maybe that's accepted from an insolvency standpoint. But then you've got $5,000 there, where between the 15 and the 20 sales price, where you've got potential return of basis, and that could be taxable. So consult your CPA for sure. The last big disclosure that everyone wants to know is, what is this going to do for my credit? That is a very complicated thing, but generally speaking, the easy answer is, if you remain current, you'll be okay. You won't have too much or even any impact on your credit score. That's the key determination for credit impact. There is really no short sale designation for your credit report, so it's just going to be, typically they would under the Fair Credit Reporting Act, they should report as settled as agreed or paid in full for less than what was owed, something to that effect. There's some variations off of that depending on what the lender's policies are. But generally, if that's the case and you're current, you should be able to escape with minimal to no credit impact. In fact, your debt-to-income ratios will go down, and so you could actually see an uptick in your credit score. One or two other disclosures. One, Fannie Mae's current policy is to not allow you to buy another house after you do a short sale, even if you are current, for 3 years. Obviously, that's subject to change at any time. And the important point here, in addition to that, is not every lender needs to sell their loan to Fannie Mae. So just because Fannie's policy is that way doesn't mean you can't get a loan for 3 years. We've had people who've gone through a short sale and are undercurrent, and I've talked to a loan officer who said they can fund them in 6 months. So just to give you a sense. Certainly, just by way of comparison, the credit impact of a short sale is going to be much less severe no matter what than either a foreclosure or deed in lieu of foreclosure. That's going to be a lot bigger hit. So hopefully that answers a lot of the questions there. If you have more, feel free to get in touch with us. A couple of just very, very quickly, a couple of just miscellaneous topics that people like to ask about. There's a HAFA program, that's the program under Treasury for processing short sales. They do programmatically waive any deficiency judgments. There is also a $3,000 moving allowance associated with that program. They do provide incentives to servicers to quicken the pace, and there are some timetables that the servicers have to abide by to process these short sales. Unfortunately, HAFA has largely not worked the way that its founders intended. Many lenders are not complying with the time frames. They just can't process it or refuse to process it that quickly. Also, there are limits to how much second liens and junior liens can receive as part of the process, and so it really just does not work if you've got junior liens. There's a limit of $6,000 that you can pay for a junior lien holder, and that frequently will not be accepted by a second lien holder, who also, by the way, has to waive their deficiency judgment rights. So if you have a second lien, usually HAFA is just not a good way to go. And also, there's no real true disclosure for HAFA, so there's still an incentive for servicers to provide kind of artificially high numbers. So we'll see where it ends up. HAFA is starting to pick up a little bit in the market now. More deals are getting closed through that program, but ultimately we'll still have to sort of see where things end up. PMI mortgage insurance. There are a lot of things to mortgage insurance. Typically, though, the important things to remember: they will request a prom note or cash contribution. They're only reimbursing the investor for part of their loss, but PMI companies do have rights to approve the deal because their policy is getting hit. There is a claim made on their insurance policy, so they will need to approve the deal. But they will provide a deficiency waiver subject to that that note or prom note, or excuse me, cash contribution or prom note. We've had to fight battles with PMI companies. Each one is different, and of course their policies change from time to time. The last thing to note, FHA, we've already kind of talked about this a lot. They also waive the deficiency if you have an FHA loan. You do have to be an owner-occupant. That's really important. If you've moved out, technically under the rules, you're not eligible to do a short sale under FHA. There may be a way or two around that, but we'd have to talk on a case-by-case basis. There is a $1,000 moving allowance that's given to the homeowner, which can be used to pay junior liens or other things, or it can just be a bonus to the homeowner. The things that we see with FHA the most are, some delays in the process because they will order both an appraisal and title work before they will issue their form. It's called an approval to participate form, which allows you, the homeowner, to be eligible for an FHA short sale. It's not a full-blown approval of the deal, it's just an approval to get into the program. And that title work will sometimes uncover things that would normally be removed in due course by a title company, but cause delays because they have to be removed before that approval to participate form is issued. There is $1,500 allocated to junior lien holders, and importantly, there's only 4 months of marketing time. There's no exceptions to this. There's only a 4-month window after you get that approval to participate form to find a buyer that meets the investing guidelines of the or the numerical guidelines of the FHA program. Okay, I hope that's helpful. If you do have any questions, please do enter into our comment section. And you should be receiving, after you finish this, a link or other means of obtaining the short sale package. Thanks so much for listening. We really do hope we can be a help to you in this time of trouble, and we look forward to working with you.